And we want to live stream to YouTube, see if that works. Insufficient authentication scopes. Well, that's disappointing. Okay, won't go live too. Good morning. Welcome to Probate Weekly. I'm Bill Gross at Bill Gross Probate on social media. And Probate Weekly, we do every Thursday morning. We do it live at 9 a.m. Pacific time via Zoom call. You're welcome to come in there. And then we broadcast it on social media on YouTube, Facebook, LinkedIn, Twitch, X, any place else. We'll do it for free. Really excited to have here today, I believe, third-time guest. And really one of my favorite attorneys, Mina Sirkin, is somebody who I met very early in my process of building out my business. Mina Sirkin of the Sirkin Law Group. Mina, thank you for joining us today.
Thank you for having me again.
And I think one of the things that distinguishes you, not your firm, but you personally, is your focus is on litigation as to probate administration.
Sure.
Now, you
Yes.
happen to have a fellow attorney who does your probate administration in your law firm that you know pretty well, right? So your husband does the probate administration type cases, then you handle the litigation cases. Is that how it works?
Sure. Yeah. My husband and I have done this for the last 32 years. He handles the non-litigated matters, and I handle mostly litigated matters. Although we try to have more non-litigated matters, it just, we don't have a choice as to what comes in. So whatever comes in, we have to determine who gets that case.
And it sounds to me like a great husband-wife team. For me in my household, as soon as something goes wrong, I call my wife. So I can imagine your husband has a probate, things come along, all of a sudden turns litigation. Mina, I need
Yeah,
your help.
that's true. That's very true. But
Okay.
yeah.
And so I literally met Mina by going to court. One of the things I recommend to all agents, whether no matter what county you're in or state you're in, to be better at this process, to learn. I went to court every day, and I did that for about 30 days initially. And I saw her and another attorney, and they were arguing. I noticed kind of the process went back and forth, and took the opportunity to reach out to her at that time. And so I think that that's the benefit of of going to court. You learn, you become more valuable, as well as look for opportunities to help somebody. And so again, Mina focuses on the litigation side. Her husband handles the more routine, I guess you might say, administrative type work. So we'll talk a little bit about the litigation. I know you wanted to bring up in one of my list of topics is what are the typical issues or the underlying issues that cause a probate to go from everything's fine, it's just paperwork administration, to all of a sudden we have some conflict or it rises to litigation. What is the typical issues that cause that?
All of these issues that come about in probate have underlying psychological themes.
Ooh.
All of them. So most of these cases, if you're talking about the common denominator litigation that happens among siblings, it always emanates from how parents behave towards the end of their life, and previous to that, how they treated their children in terms of comparison types and in terms of giving more benefits to one than the other. So parents, as a general rule, they generally love their children the same, but they don't always feel that they should give each of them equal shares. Sometimes one child needs more, sometimes one is farther away from the parents geographically. Sometimes one provides more help to the parents, and all of these dynamics, they all at times translate into litigation. So as far as probate realtors are concerned, I think that you need to know these things. And you can only capture this by conversing with potential clients and with the executor, with beneficiaries. The beneficiaries are identified on the probate petitions. If you have pulled the probate petition, you know who these people are. If you have conversations with them, you guys are free to have conversations with people. We're not that free. But if you do have conversations, you can ask, some pointed questions to them as to, You know, are there dynamics between you and your siblings that could be potentially a problem? And that makes you aware of what could happen in a case. How that affects the realtors is that they, first of all, it helps you find some solutions sometimes to these basic problems. Sometimes the problem could be as simple as the green vase. You know, the green vase has a story among probate lawyers that people often enough fight about something really simple, such as a green vase that nobody, or green lamp, sometimes we call it, that everybody says they want, but they really don't want that. They just want to feel like they got a little bit more than their sibling. And that this dynamic isn't really known until you're kind of, you know, we're knee deep into litigation. But you may be able to find this piece of information and try to find some solutions to it. There are some solutions to the simpler problems. Maybe there aren't to some of the more complex issues, like why mom treated one child better than the others, or why mom would want to leave a life estate to one child and not to the rest of them. These are things that you can only capture by speaking to them. But some of them are resolvable. Some of them are resolvable with mediation before anybody gets into court. And everybody would benefit from that. And the realtor's role can sometimes be more than just a realtor, can be to identify the dynamics that can lead to a sale. I think that can be an underlying theme for everyone. And in every settlement that I know of, if there is real property, sometimes the real property is sold. And in, I would say 85% of the cases, in order to get to a settlement, we need cash. And that cash requires that there be a sale. It could be a sale of personal property, liquidation of stocks, liquidation of real estate, but it results in something that can give us cash to settle among parties. So keep that in mind. So if you can get to the step before, which is the settlement, it is likely you will get to the sale. So I wanted to make people aware of that and ask me the next question.
Well, there's a lot to unpack there. You know, for those of you watching, I had met Mina in court and we'd done some business together. And then I would notice pre-COVID, when people went to court every day, it seemed like she knew every probate attorney there. And part of that, I think, is the nature of attorneys, particularly litigators, is it's a small group and they kind of know each other. They go against each other. They refer business to each other. And so she has a lot of information. I want to unpack a little bit. You mentioned the green lamp, and I reflect back on my life. My mother had a conflict with her sisters and brothers over some lusters. I remember my mother's mother passed when she was young, and she didn't get the lusters. The other sister got the lusters. I didn't know what lusters were. And I remember, 15 years later, I guess, my grandpa finally came out and made peace with my mom and gave her the lusters. And there's just these stupid little crystal things. But to my mom, that symbolized her relationship to her long deceased mother. And so these things become very emotional. And so one of the questions I would ask you is, I think also these emotions build over time, meaning I know as a real estate agent, I know there's nothing good that happens from the time I list a house until it closes, because all that can happen is somebody can say, hey, you're cheating me. The sooner we close, that's less likely to happen. As long as we do our job properly. I'm not talking about cheating somebody and getting away with it. I'm saying the incorrect emotions being displaced on the real estate. So how often does that happen in probate, where things start friendly and all of a sudden one day somebody mentions the Green Lantern or the lusters and it blows into litigation versus starting out of the gate as litigation? You commonly brought in right away, we're going to mattresses, or is it common that these things fall apart over time?
They tend to fall apart generally in the first year after somebody dies.
Mhm.
Part of the grieving process includes a period of time of anger. You know, before you get to depression and resolution, first you get to disbelief. You know, you've got some questions as to why things happened. It leads to anger, depression, and resolution. And that's a 1 year process generally. It varies from family to family. Sometimes there's underlying things that occurred, but it happens sometime during that period of time. Now, sometimes there's a delay. Sometimes the parent has passed away many years ago and nothing's happened with the property. You know, people sometimes just don't do anything. Then they, somebody, figures out that, hey, look, we have an interest in this thing, or we've waited too long. We let our siblings kind of stay in the property
Right.
for a couple years, and now it's time.
Right.
Sometimes it happens that way. But generally, the anger stage occurs within about the first year after death.
And that's, I think, as real estate agents, we should be helping our customers who have control and the ability to get the process started and close quickly and get the right probate administrator attorney, because so often they pick an attorney they know who does DUIs and does divorces and might be a great attorney, great person, but doesn't know the intricacies, particularly in LA County, of probate court. And so what could have closed maybe in a year and a half is lingering and lingering. And all it takes is one of the siblings to say, hey, you're taking too long. You're doing this on purpose. You're doing this to cheat me. And that's when I think some of these things kind of flare up a little bit. So one of the things you mentioned earlier was about getting reviewing the documents. And for those listening, certainly in LA County, we're really blessed to have a service. We can go online and get documents in a case. But also, I encourage agents to ask their customer, hey, you got copied, on the filing. Can I get a look at it and make sure I understand the case fully? And so I would encourage everybody to make sure you feel free to ask your customer. Here you have the attorney saying that you should review the documents. I think, Mina, you assume we get copies of them. But I think the truth is many of us don't even know that there are copies our customers have. We don't know that the filing has the siblings and such. But I think you would say that it's a good practice to ask if it's our customer to review these. And these are public record documents primarily, correct?
Right. Generally, they are. Petitions are public record. They usually have a list of persons interested in the estate attached to it. So, a realtor is free to look at those and, determine, what the relationships are. Sometimes you'll find out that there are no relationships.
Right.
Sometimes, we've actually closed probate cases where we couldn't find the beneficiary of the will, and we placed the money with the county treasurer by court order. And several years later, people come out of the woodworks
Hmm.
claiming that they have a right to that
Right.
asset, etc.
Right.
And then the court has to decide whether or not they want to allow them to have that asset or not, or whether or not they were entitled to it under the terms of the will. So these are, there's a lot of things that you could find out if you go to the courthouse. You could certainly look at these documents for free.
Yeah.
If you know some of the case numbers, you can, continuously track them. Uh,
Mhm.
but people don't do that. People don't make the effort to show up to court 30 days in a row.
Right.
Whatever you put into it, that's what you're going to get out. If you want to go into an area, you got to know who is working in that area. I think that would be very helpful to you to go to the courthouse, wherever you're at. Doesn't
Right.
matter where. Sometimes in the very small counties, probate is only heard one morning.
Right.
You have to figure out when that is.
Right.
Sometimes they only have one judge. We have 10. So in this particular courthouse, you have to kind of make the rounds from department to department and, know where they're located. But in, a small town, it might be just one room and that's where you go.
Yeah, that's a good point. In LA, we're the largest probate court in America, and it's all consolidated in one building. And so when I went every day, there was something to see going on. I literally saw at least one sale a day. And to be honest, I saw typically two or three, but in most counties, it's one day a week or 2 days a week. And so whatever area you're in, you should be there, I think, at least to start for a month or so. Check it out every, Tuesday, if that's when it is, and find out what time the hearing's heard and make sure you get there. So that's a really good point. Um, I know that, litigation, varies in terms of type and scope, but can you give me an idea are you comfortable sharing kind of what's the typical case that you deal with? How much is the estate? And then also at some point, how much fees are we talking about? Because I think sometimes I know as realtors, we get a phone call and it's like, hey, my brother's cheating me. I want to sue him. And well, great. Tell me about your financial situation. And they're destitute. And it's like, it's going to cost a lot of money in most cases to litigate. Can you share a little bit about kind of what some common numbers are that we should be aware of as we maybe vet cases before we bring them to you, or what kind of cases you like to have brought to you?
A case without litigation, that's a simple probate, can cost somewhere between 5 and 10% to administer. When you get into litigation, that number is exponentially higher,
Mm,
depending on the scope of the litigation, depending on the type of the case. Sometimes you have a forgery case. Forgery cases are expensive. People don't understand that. That you need an expert witness. Each side gets an expert witness. Each side takes depositions, plus the depositions of the experts. There's forensics work that needs to go into forgery cases, which means somebody's going to have to gather up, you know, original exemplars of the signatures. Those types of cases are, you know, the number is can far exceed even the beneficiary's interest. And you need to be aware of that when you litigate those cases. If a case cannot be settled by mediation, then, you know, the explanation to the client is that, hey, if you don't settle by this date, if you get to the date of trial, you have now potentially spent every dollar you may actually get back, even if you won at trial. And that's a reality in these types of cases. So, non-litigated cases, you can sort of give a parameter for, but litigated cases, hundreds of thousands of dollars can be spent in a will contest, so to speak, or trust contest.
No, I've had a couple cases where there were forgeries that were pretty obvious. In one case, we had one where the decedent died before the forged document. Like we knew the date of death, and we had the forged document was like 2 years later. So everyone was not only did a signature look anything close, but that was kind of an obvious one, right?
Yeah.
And so in that case, the attorney had a forgery expert and provided that, and then obviously threatened whatever legal action was possible, and it kind of folded like a house of cards. What would be a case where there's two sides to it? I mean, I guess the signature, the forgery was pretty good, and the other side, or is it a matter of the capacity of the signer that the signature looks to be past the date when they were competent to sign? What would be at issue when two people have a forged document and you have two different experts and they're disagreeing? Is it really um, that hard to distinguish, I guess?
Sometimes they are, sometimes they're hard to distinguish, it depends on the skill level of the forger and their intent. So,
Mm,
when they say somebody has forged something, you have to really ask about all the other circumstantial evidence of things. We had one where um, we knew that the person died without a will because a week before she died, she had told her brother that, everything of mine goes to you by law anyway, so, and I don't have a will. But then the tenants had shown up with a will. But the good thing was that the brother had actually come into the property and taken away the computer of the decedent and gave that computer to a forensics examiner,
oh
only to
wow.
find out that after date of death, somebody had entered the property and was doing searches for online wills on the decedent's computer. So it was complex, and the only people who had access to that unit were the tenants because they had a relationship with the lady who was the landlord. But there are some times where that you don't find that piece of evidence that's that glaring. And then you have to look for other things. You have to look for other circumstantial evidence of wrongdoings. Could be undue influence mixed with, forgery. Sometimes that's the case.
I was involved in a case, it wasn't with you, where the tenant had forged not just a lease, but an option to purchase at a ridiculously low price and was living in the property, squatting in it basically. And so here are the errors, they had theoretically would have to maintain the property taxes or insurance on the property while the squatter's living there for free, basically, and claiming he has a right to buy the property at that low price. And I guess the tenant put his money into a litigation rather than paying a lease. And at the end, the family just sold the property with the problem.
With him in
Yeah,
it.
there was investors who, the house might have been worth $1 million, and his option purchase was like 300,000 or something, 400,000, and there are investors who are willing to pay a couple $100,000 just to roll the dice on their own. And I think, whether they send in somebody with a gun, I'm not advocating that,
Oh,
but
no.
it comes to that. I mean, there are people who get that crazy about what these things go on. And you talk about $500,000. People do some crazy things for $500,000. We hear these stories of these crimes that go on. So this is what happens when these things aren't taken care of. And I think I always say to people, there's nothing good that happens once this problem is identified. There's nothing good that happens after you identify it. It just gets worse and more expensive and
Right.
more problematic.
Exactly. But, solutions do come about in very strange ways sometimes. Sometimes you don't know who can bring you a settlement. It's difficult. Sometimes the realtors play a really big role in getting the family to understand that how much things cost.
Right.
Okay, people don't know. When they hear it from a lawyer, oh, they think that's nothing. But when they hear it from other professionals, it
Right.
has a different impact.
Right.
So it's important for you guys to know. You could tell how much litigation costs. If at the end of a probate case, if you that started out with litigation, you later visit the probate file. Often enough, you can see what if there was a settlement, what the attorney's fees are. Sometimes you can't, but sometimes you can. And
Mm.
you can see how large they can get because, people are so entrenched in the emotional part of the case that they forget that there's an economic side of the case that you really have to consider when you move forward. Just because you don't really like your sibling or you don't like your dad's uh third wife doesn't mean that you should spend that money. And I think lawyers, as lawyers, if we've taken a case on a contingency, we continuously tell our clients, you've now spent this much. You're not, even if I take 40% of your case, for example, that 40% may be this small, but your settlement at the outset, you'd always end up with more money in your hand if you try to negotiate a settlement
Right.
earlier
Right.
than later. And
Right.
contingency cases are not great for us either if we end up spending tons and tons and tons of time in a case.
And expenses.
But when you take on a contingency case, you're not spending that time on your other paying cases.
Right.
So it's not, it really isn't great unless you actually get to a settlement, pretty quickly.
And really, that's one of the reasons I do this podcast. I've interviewed, for example, several partition attorneys, right? And I've been involved as a realtor in cases where there's, disputes, and I can say to the other party in a way that the attorney can't. I can talk to the other party. I'm allowed to talk to whoever I want to talk to as far as the real estate side. Um, Listen, I've done a couple of these, and what always happens is if it goes to trial, you're going to lose because we have the right to sell the property. You're going to pay any expenses that are caused and probably the legal fees on both sides of the case. There's no real winning formula to this situation, and I can get their attention in a way that perhaps the attorney sounds like the attorney, and I'm just the realtor saying it's not going to work out well for you. And I think it's important that we play, where we can and make sure we coordinate with our customer and the attorney if appropriate. But we can help move things forward in a way to supplement and be part of the team negotiating, because almost like she said, almost always settling and getting along is much better than going to war and everybody's kind of flying around with expenses and such. Okay, let me get some housekeeping done just real quick. I love this
Sure.
conversation, but we also have to make sure let people know where we're at. So this is Probate Weekly, and we do this every Thursday morning live on Zoom, and then we broadcast it later in the day in LinkedIn, Facebook, YouTube, and such. But we also have a Facebook group to continue the conversation. You're welcome to go there. You're also welcome to go there and post your own content. So if you're trying to promote your business, you'll see I put other interviews, but I have other agents who come in and put their content to promote their probate related or trust administration related business. Love to have you guys do that. We have several people who've been successful at that. If you want to sign up and get notified about the Zoom link, go to probateweekly.com and just put your email address in and you'll get notification. You also can scroll down and get us on various audio formats, Spotify and Apple and all that stuff, as well as the past issues or past episodes on YouTube. Our guest today is Mina Sirkin, Sirkin Law Group. LosAngelesProbateLawyer.com is one of the websites they have. And if you go there, you'll see a picture of her husband, Evan, and more importantly, our favorite attorney today, Mina Sirkin, and she's a probate specialist as well as a litigation specialist. So love to have you there. It was interesting. I mean, just FYI, when I went to prepare for this call today, I searched Mina Sirkin probate. Oh, I typed with that probate attorney. It's just interesting that we all have to pay attention to this. If customers don't have a link to us here to get to her, I have to scroll through 5 competitors, right? And so that's why we don't want to rely on a Google search. We want to give people a link for our business as well as people refer them to, because you can imagine a customer might Google search Mina Sirkin probate attorney and get this and go, oh, I'll click on that. That must be her. No, it's, Google does that. I'm sure they figured out that sponsored link is almost impossible to, that's how they make money selling those ads. So for everybody, but anyhow, it's Los Angeles Probate Lawyer.com is the website, and you can find her there as well. SirkinLawGroup.com is another way you can find her there. Anne says, you've reiterated everything that I've recently learned in my own family. That doesn't sound good, Anne. If you're learning about probate litigation with your own family, it's not like you guys are taking a class together. It doesn't sound like a positive outcome, but there you go. Okay. Let's talk a little bit about special administration. I met you. It was a case where you had a decedent, you had a family member, and you had another purported family member, purported relationship. That was a whole subject of litigation. What was the nature of the relationship? And I think this is something that a lot of attorneys didn't know about that I saw in court that you did, which is that you can litigate who gets the money or you can litigate who gets the property. But if you both agree you're going to sell the property, you can sell the property while you argue over who gets the money, right? And the way you do that is appointing a special administrator. Can you talk about that a little bit?
A special administrator is someone who comes in for a limited purpose. They come in for the purpose of either selling it or protecting the property. Sometimes there are squatters. Sometimes, the property requires, something. There's a condominium that has a, special assessment or something that needs to be done with respect to the property. But, people can agree that ultimately it needs to be sold. And because it needs to be sold, the money can be locked up in a blocked account so that it doesn't go anywhere, so no one spends it while the parties go to resolve their problem. And I think the case that you're referring to was where a girlfriend of the decedent had claimed to have an oral will, contract for an oral will, which went all the way through a trial. Okay. She lost, and then she filed a $430,000 creditor claim and tried to go at it from a different angle. That went to a civil lawsuit, and it ended up settling in the civil lawsuit for $23,000 to her. So, and that was just nuisance value, essentially, to just be done with her. But she didn't give up. She didn't, I mean, this case went on and on. I think the decedent died in 2018, and it just ended last year, believe it or not. The property was sold fairly quickly, and that money stayed in a blocked account. But it was unfortunate.
Yeah. And I just remember the client, having to relive this relationship. I think he was an uncle of the decedent, if I'm right.
Right. That's correct.
And, but, every time you have to go to court, every time you have to write a check, every time you have to sign a piece of paper, you're being reminded about this relationship. And then this woman was just relentless. Was the same, I don't want to disparage anybody, but was it the same attorney on the civil suit as the probate, or was that a different one?
Yes, it was the same attorney. The problem wasn't the attorney. The attorney was a very, very good guy. His client was the one who was just instigating all these different things. The creditor claim that she had actually produced was very bogus. I mean, it was several pages of these claims, half of them really didn't even pertain to the case, but it is sometimes things like that happen. And the court doesn't care that you claim that the creditor claim isn't valid. The court wants to know about the details, why you think they're not
Right.
valid.
Right.
So, but it did resolve at the end of the case. It just was too long for that.
One of the now, commonly when cases are litigated, by definition, you need court confirmation because the other one of the parties won't agree to a notice of proposed action, right? So you can have a case where you have full authority, but if somebody objects, one of the solutions is, well, we'll take the sale and we'll get the court to agree to it. But if it's litigated, it almost always, I think, especially if you don't have the letters issued and that's what's being litigated, and you have a special administrator, it's going to require court confirmation. So, I know that that's my area that I specialize in. I actually track all those. Those in LA County, I always tell agents, don't take your first listing as a court confirmation on your own. Find somebody to co-list with that's done one because they're more complicated. Talk a bit about the difference between selling property in probate on a standard case versus selling it when you need to have a court confirmation process.
A lot of times we use court confirmations to make sure that the beneficiaries who are faced with, a property with a price are not dissatisfied with the sales price. So when a property is sold with court confirmation, not only have you gotten the best available buyer in the first stage, okay, but it goes further to court confirmation. And at the court confirmation, other overbidders can come and bid for the property. Sometimes you have one beneficiary who's just dissatisfied with no matter what you do. And we think, okay, well, Mr. X, no matter what we do, he's going to think that the property is undersold. So we take that to court confirmation, and then the court approves the sale. If the court approves the sale, that is the determinant as to what the value, the highest value possible for that property is. And often enough, if a beneficiary says, no, you're underselling, we say, well, why do you come and overbid? If
Right.
you think that it's worth more, come to court and overbid. Sometimes that takes away the edge, but not always. But it's a good method for an executor or administrator to protect themselves.
I've literally been in cases where the beneficiary at the sale said, you're underselling it. And literally the judge turned to him and said, well, why aren't you bidding on the property? Did you not have a chance? Were you not noticed? Did you not get a chance to look at the property? And they had to say, well, yeah, we had a chance to look and we talked to people, but we couldn't get it, the money together. Well, everybody thinks it's worth more if you're not going to buy it, but there you go. And so the process in California is a little different, a little stricter than in most states. And again, LA County being the biggest probate court, what happens rarely, a lot of rare things happen at once. It becomes significant in LA County, for example. We have 500 probate cases a month, and we have maybe 30 sales at court a month. And one of the processes is there's a number of steps. It surprises me. I mean, I don't know if you see this or not, because on the litigation side, maybe you don't need to watch this closely. It's, less than 1 in 4 court hearings result in the sale being confirmed. Meaning, I've tracked this now for 5 years, and 3/4 of the time there is some minor technical deficiency. Notice wasn't done right, publication not done right, the contract was accepted beforehand, and the sale gets delayed another 30 days, 60 days. In COVID time, it was delayed until whenever we reopen the court again. Why do you think it happens so often? Is it just that so many attorneys don't really work probate regularly and watch it? Is it that complicated a process that requires that? But it's just amazing to me how often they get delayed or continued.
It's a complicated process to begin with. For a first-time person who does it, there's a fairly high learning curve. But once you've done it 2 or 3 times, it becomes second nature. I mean, knowing what to do first, that you really have to have this publication occur, and then that you can't take offers before the end date of that publication is really important. People miss that all the time. We have to sometimes go fix that later, but there's been situations where, the court delays it 2 or 3 times, you forgot to give notice to this one. If you forget to give notice to the occupant of the property, that can cause a problem. And these are just small details, but and there's the underlying probate code, and then there's the local rules. Local rules add things on top of the items. Like, for example, that our local rules require the attorney to show up in person. They want us to go there in person. During COVID, it was impossible, but now the judges have now said, if you're selling a property, you need to be here. And there's a reason for that, because you cannot see the full scope of the courtroom when you're on video. It's like this. You cannot see what's going on. You can't see how many bidders there are. You can't see, you really, even if you try to pre-qualify everybody beforehand, if somebody just shows up with a cashier's check that morning, you won't be able to get the check from them to make sure they're qualified to bid. So there's a
And they're entitled to do that by law, right? It's not like they're doing something wrong. The law, the law is encouraging overbidding to protect the estate. And so what they don't want to do is invalidate somebody because they show up with a check. That person should be welcomed and given every chance to bid according to the law.
Right, right. And there's more dynamics. When you go into a sale, you're seeing the faces, you're seeing expressions of people. Half of that stuff it's missed on video. You can't even see the expression on the judge's face. Sometimes we just see the side of a judge's face on the video. So, there's a lot to be said about going to court. As little of it as occurs now, because now everybody tries to take advantage of, maximizing their time by using the video. There's value to it.
Right.
I used to do my drive was an hour and a half to 2 hours there every day, but there was value to that. Now it's changed a bit now, but you could still do that.
Right. Well, and every agent on this call, I definitely recommend, if you have a court sale confirmation, whether you represent the buyer or the seller, go to court, get there early, watch the process and learn, meet the attorney, meet the parties who are there. It's definitely worthwhile from a networking point of view and a learning point of view. 100%. I used to go to court every day, and I would purposely, because I had the calendar, would go to where there were sales. And I watched things. In fact, the case, I don't know if you remember this, Mina, but the case that we had, I had seen that judge, and this was very rare because the law says that the court does an inventory and appraisal report, a DE 160, and whatever that property appraisal, in essence, comes in at, you have to sell the property for at least 90% of that number. And we had a case where the property inside had significant amount of mold, bad mold. It was black, it was deep in the walls, it was unknown. And so when you compare two condos, one that has mold, one that doesn't, you're not going to get 90% sold as is with a mold in there. And so I'd seen that judge approve a sale on exception basis because the attorney presented it. Hey, we know this is the law. We're asking for an exception. Here's the reason why it was good. And I went there and we made this presentation on this case as well. And the judge asked me, and I just said, yes, there's black mold and we have quotes, and the buyer is a very sophisticated investor because he's going to remediate the mold and he has other properties in that building. And the judge approved it. And so sometimes when attorneys say, well, you can't sell for less than 90%, the thing that you just said, Mina, is that sometimes you can get exceptions. You do that as well as watching the notes, right? One of the things that you taught me, or I watched, you and noticed, was that the court kind of gives you a cheat sheet before the hearing as to what they're looking for, and you have a chance to either address it before the hearing, which is ideal, or at the hearing. So talk a little bit about that process as an attorney, and then why do so many attorneys not even pay attention? How can that happen? I don't understand.
It happens. Probate notes are a list of things that the court's attorney puts out that says, hey, we have questions about these things. These are the things you need to respond to for us to be able to be satisfied that at least the procedural items are complied with. So if you read them, sometimes they don't come out on time. This is something that
Right.
It's kind of out of our control, but if you continuously look for them, and they're free on, at least in the LA court area, you can get them for free. you could see what potential issues come up. You can actually make a list of them, for yourself as a realtor, and make sure that that shows up in your checklist. That's a really good checklist for you to have by watching several of the sales and then reviewing the notes that come up before the hearings on those sales to see
Right.
what the potential problems, and then figuring out how the attorneys fix the problems, because there are supplements that people file to clear these notes in order to make the sale happen. So that's a learning process, but it's a really good one if you can develop your own checklist from it.
Yeah, and to her point, like on the probate filing, it'll ask her how is the property marketed, and sometimes the filing is insufficient, and the probate court's attorney will say, no proof of property being marketed. Well, the supplement then went on and explained all the things the realtor did. And I just took that and made it a template. And so when an attorney files the petition, I said, well, here's a template that, on this property, what we did to market the property so that the probate attorney sees that, goes, oh, wow, he hit all the points. Yeah, because I know what points you're supposed to hit. And so the goal of this is to learn and improve and grow. I'm sure it's different in every county. I'm sure it's different in different states, but we might as well learn from other people's work and kind of, stand on their shoulders rather than try to reinvent the wheels ourselves.
Sure.
So, here's a question. And I don't mean to, I guess I do mean to put you on the spot, but you're welcome to get off the spot if you're not comfortable. True or false, customers are better even with a basic estate plan done with an online service that you might say isn't ideal, 90% of the time than having nothing at all.
At times, it can be true or false at different times. When people attempt to do self-help estate planning, a lot of things can go wrong. Okay. You don't catch that at the time that the plan is done. You catch it much later. So, we have there's also things that you cannot predict. Here's an example of one. 90-year-old woman is taken to one of these outfits that creates documents where it's a self-help service. She's taken by caregivers. The people who are processing those forms, they're using a software online, and they're document preparers. They don't have any obligation to check for undue influence, check for capacity. They don't do any of those. Okay. So where you talk about, where things can go wrong, that woman had an estate plan. It left it 100% to the caregiver as opposed to her special needs child. So there was no checks and balances there. There was no one to ask questions as to, hey, why are you coming and taking your property out of your old trust and putting it in a new trust? Nobody asked her that. So when, it's, you just don't have someone just asking for basic questions. They're processing papers. That's a different process as to find out whether or not that paper has value to this person or not. If that person had done some investigation and asked, 3 or 4 questions about, hey, you've got this daughter. Is your daughter okay? Is she normal? They would have found out that this woman really cares about taking care of that one child that she has who's a special needs child. And they wouldn't have gone and done a new trust that puts the property and gives it to the caregiver.
So talk a bit about the additional obligations on an attorney versus, you mentioned, I think in passing, do you have an obligation to check capacity? Do you have an obligation to check? Now, obviously, it's not foolproof. Do you have an obligation to check for undue influence? Like, what does that look like? What is somebody able to rely on that attorney should be able to accomplish?
The attorney will ask questions. When you ask questions about someone's family situation, you capture a lot of information. You'd be able to capture in the information of, okay, there's a special needs kid out there that is an adult, but that needs something in the future if the mother's gone. We do ask questions about capacity. We have a conversation with the client to capture did they remember what I just told them 5 minutes ago, or are they asking me the same question over and over and over again. We ask about details about their assets. We want to know if they're competent enough to understand their assets and their loved ones. When you go to an online service, that's all lost. So if somebody is incompetent, either they're not going to be able to do this themselves, or somebody else is doing it for them with some agenda. There's usually someone with an agenda that does that. But there's tons of these forms that are being done all the time, and some of them go wrong, and but not all of them, obviously.
Um, I hear this all the time. I know the answer, I think, but I'd love to hear it from a professional. True or false, if I have a trust, I can't be sued.
False.
100% false.
False, false. Yeah, revocable trust, you can be sued regardless. Even if you have an irrevocable trust, you can still be sued. Whether or not that trust can be attached is a whole other thing. It doesn't prevent the lawsuit necessarily.
Right.
It might prevent collection at some point, or collection of some of the assets, but it's a false premise to think that a trust will prevent any kind of lawsuit.
100% false. Yeah, definitely. The biggest misconception I think in probate real estate is I can avoid probate because I have a will. Now that might be true in other states, but is that true in California?
No, and there's other ways to avoid probate with respect to real estate. But the will by itself is just a set of instructions to the court as to how you want your assets distributed.
In probate.
In probate. There's, small estates that can skip the formal probate process. And you have this one small petition with respect to properties that's not a full probate. But the will itself doesn't do anything. Sometimes we have people that come up with multiple wills. One family member comes up with will number one, somebody else shows up with a codicil. The third family member shows up with a third will. I mean, the will by itself is not meaningful in terms of avoiding probate.
I'd love to have a case where a will 9 months into the probate, all of a sudden a will pops up, and of course, leaves things to the person who found the will.
Found the will. Yeah.
And the signature looks funny. The whole thing is just kind of crazy. I know there's a new recently passed bill. The number escapes me. I want to say AB 216 that changes the small probate estate. But I don't think it's been signed by the governor yet. I think both houses signed it, but not by the governor. Have you seen this coming down the pipe? And what if anything, do you think that's going to do?
About making the threshold of probate $750,000.
Right.
It's talk. So we'll find out in the near future as to whether or not that's going to go into effect. It might, but there is room for that. There's room for having a larger number than right now at 184,000, roughly, will escape probate. That number was supposed to change every year incrementally, but in California, an average house somewhere between 600 and $1 million. I mean, in LA County, $1 million doesn't buy you much. Maybe it might buy you a condo. So maybe there's room for that. Maybe there's room to have a shortened probate.
Right.
It does not, unfortunately, I don't think that it avoids a lot of the problems that we have regarding the wills and contests and trusts and all that. But I think it might be helpful in some areas.
Yeah, I've seen some discussions. I know the LA County Bar had a presentation, have a high level overview of it, but the forms aren't out yet. But it seems to me that there's also some provisions there that create opportunities for more fraud. So sometimes you end up solving one problem and then creating a whole nother one where, if you can transfer title of property without going through probate, boy, to criminals, that's like, well, it's easier now to steal property than it was before. I don't know that's going to solve our problems in the long run. So how do you, one of the things that's interesting about this field, one day my wife was a real estate agent before I retired her. And, she said to me, this is a great field to be in that there's no competition. But I think like any business, Well, my business has been great, and I'm just so thankful for it. At the same time, while maybe real estate overall is having a tough time, our sales are down 30% as an industry. We're in a depression. Probate real estate has continued to grow. That also attracts new players in, and I see every day new real estate agents who claim to be probate experts and are competing. But I don't see that in the attorneys. I don't see the same intense growth on, and maybe I'm missing it, maybe I'm not as privy to as you are. It seems the opposite, that the fewer probate attorneys who I would say are experts in their niche, in your case, litigation and other ones and other pieces of the pie, um, there doesn't seem to be a robust increase of population, the opposite, that they stand out more. What do you see as a businesswoman? What do you see as the competitive landscape, today and going forward?
There's always competition. There's always competition at every layer. There's usually three age layers of probate attorneys. And as time goes on, these layers change. When I came into the practice, there were very few young people in the practice. I think it was me and maybe three other people. But now I'm now approaching the tail end of that third section, third age level. And so I see a lot of my colleagues are retiring faster and faster, but the
Right.
ratio at which the new attorneys are coming in, I don't think it's that many now. The state bar has been trying to encourage people to, get licenses, and they try to allow for provisional licenses, et cetera, mainly because I think they also noticed that the people coming into the practice are not as many as they used to be.
Yeah.
At least the ratios are smaller, but there's always competition. I don't think anybody can worry about competition. You have to just focus on getting better at what you do, and hopefully, with some marketing, you're able to channel your expertise and provide that service to people. But, there's anything's competitive, if you can go to the market and, try to buy a soda, and you'd be overwhelmed by the number of sodas that are,
Yeah.
on the shelves. You
Yeah.
still have to make your selection based on, your taste and your needs. So somebody might, I don't know, do they still have RC Cola? I don't remember that anymore, but
I don't
one,
know.
yeah, one person may like Coca-Cola, the other person might like, Fanta or whatever they exist now. Um, but the same goes with attorneys.
One of the other kind of related niches is fiduciaries, which are often attorneys, but many times are not attorneys. And that's another field that just does not seem like there's enough people going into that. Yet at the same time, as our population gets older and there's more assets in that group, there's more demand for that. Um, uh, to me, it seems like a opportunity for non-attorneys, maybe to have a financial background, maybe a CPA background, maybe paralegal of some sort, to enter into that. What do you see as far as that? Is that an area that you notice as well? Or is it just something I'm noticing being the real estate agent?
I noticed that there are more younger people coming into the fiduciary business.
Mm,
That's a difficult learning curve. So many of them do have to go work for other fiduciaries to really, grasp how to do this job, and getting a bond for a younger person is difficult. So
yeah,
as they have to work with somebody else to be able to um, get the experience, and then be able to get those bonds at a later point.
last question is because we're up against time, but when I wanted to ask, I used to pre-COVID, when we went to court every day, I would see you, mingling with other attorneys and learning from some of the kind of elder statesmen. And now you're probably one of the elder, in your practice. But back then, I can't remember the name of the guy, Gary, really tall guy with the cowboy boots.
Ruttenberg, yeah.
Ruttenberg. He was like it was like a professor of probate law. He would just sit there and hold court, and he would just out of his mouth came like these pearls of wisdom about the business, and little intricate. So, obviously we don't have the court opportunity as much. You're online more often, you're not going there in person. What do you do to keep yourself sharp on what's happening in the industry and learning? I know that, it's important to you. And where do you find that opportunity for you to improve your skills and keep your knife sharp?
All of the bar associations have classes. They have most of their classes available online. Uh, so I participate in whatever I can. And there's certain conferences that are annual, and there's certain groups that meet annually. So, you want to participate in all of that if it's possible. I'm sure it's the same in your industry where, there's an annual expo or conference that people go to capture more information. But there's room to learn things on a daily basis. If you go on to the LA County Bar Association, you can become an affiliate member and
Yes.
take the classes. And I think that that's a good learning process. And then through that, you find out, who's attending these classes, who can provide you with some more information if you have questions.
Yeah, most bar associations, I'm an affiliate member of a couple, in particular LA. They had a great class yesterday on selling updates in real estate. And they also have a listserv where the people like email questions and answers amongst attorneys, and you can watch that a little bit and participate in that as well. So I encourage everybody to, if you're a real estate agent, even if you're not an attorney, usually there's an affiliate membership you can join and go to meetings. I know there was a San Bernardino had a day-long expo for their probate as well. So Mina, look, I could talk to you forever. I'm up against the hour, and I can't afford your hourly rate another hour. So, no, thank you so much for the generosity of your time and your spirit. I really appreciate, the time that we've had to work together, as well as the time you spent educating our industry. Thank you so much today.
Thank you very much for having me. I appreciate it. Take care.
And just a recap, again, this was Mina Sirkin from, and again, she's got two great domain names. Either one, if you remember, is fantastic. One is sirkinlawgroup.com, her last name, Sarkin. And there's her husband who does the administration of probates, and then she does more of the probate. And then the other one is LosAngelesProbateLawyer.com. So whichever one you remember, get it right. There's a phone number. We'll put the details in the details on the recording for watching this on YouTube or Facebook, whatever. And just a quick reminder that we have a Facebook group, probateweekly.com, to continue the conversation, ask questions, and we'll follow up with them there. Love to have you participate, and also post your probate or trust related content there as well. And then you can also go to probateweekly.com, sign up, put your email address in. You'll get notified when we're on the Zoom call. You can ask questions, participate. If you scroll down, you can also subscribe to our audio versions on Spotify and Apple and all those other places. And you also can see the past episodes on youtube.com. Again, thank you to Mina Sirkin for her participation again today. She's a 3-time guest on probateweekly.com. Thank you very much for supporting. Have a great weekend. Everybody have a great Thanksgiving. We'll see you next week.
Have a good holiday. Bye-bye.
Thanks so much. Bye.